Hey everyone, and welcome to today's video. We've got 4 different self-proclaimed sovereign citizens getting firmly corrected by 4 different judges, including our familiar returning character, Eric Martin. There's a lot to unpack today, but before we dive in, I want to give a big thanks to our sponsor, Extra Wallets. Many of you already know that Extra is a company I've partnered with for several years. They were my very first sponsor and supported me through every high and low. But beyond that, I genuinely enjoy their products. I just got back from a 3-month trip across Europe, and even with all the fancy travel gear I've collected, I still ended up relying on my Extra travel duffel bag. And of course, I don't go anywhere without my Extra smart wallet. Not only does it give me confidence with its advanced RFID protection, but it also gives me peace of mind knowing that if I misplace it, I can use the Chipolo app on Android or the Find My app on iOS to locate it and make it ring. One of the standout features is the reverse find function, which allows your wallet to help you locate your phone as well. chaos.A continues to expand its product lineup with items like the Card Holder Pro, the Smart Keyring, and the Off-Grid Backpack. I'm genuinely grateful for Extra's ongoing support. And I'd love it if you used my link in the pinned comment and description to check out their growing ecosystem of slim, sleek, smart accessories. Use code SKEPTIC at checkout for an exclusive discount for the Skeptic community.
Mr. Fox, before the court trial of possession paraphernalia and a no valid driver's license. You understand the charges?
Understand what you're charged with?
No?
No.
No. He doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is.
No.
Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth
It's
about
not
it?
easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the
Nobody's
contract.
asking you to admit to anything. I just need to make sure you understand the charge.
I'm a proud citizen, sir.
I'm shocked
Under
you're
UCC focus.
Oh, UCC? Oh, I love it. A sovereign. Golly Moses.
I really enjoy watching this judge. He's one of the most entertaining judges I've had the chance to cover. He always has a sharp, clever response whenever Mr. Fox starts causing trouble in the courtroom.
Fox, crap in one hand, hope in the other, and see if that helps. Ron said at 5,000 the meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the team.
Mr. Fox, when you sue me, make sure you spell it with 2 N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that. Next.
And yet, you're still required to show up. Funny how that works, isn't it? And is it just me? Or does this guy's voice sound oddly familiar? Almost like a cartoon character trying a little too hard.
Calendar, Mr. Calzada, could you please turn on your video for me? Yeah, hold on one second.
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you
Here
please
I
tell
am.
me? Well,
I'm here
please tell me
physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent.
But either he didn't show up or the footage never made it online. Bothell usually uploads most of their hearings, so chances are he simply didn't appear. If that's the case, a bench warrant will likely be issued. And he'll end up right back in the system. Now we're heading over to Judge Slavin's courtroom, where we're checking in on a crowd favorite and multiple Dumb of the Day award winner.
And you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
Well, right now you are not responding to my questions. So
Well, you're not responding to any of my questions. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything.
I'm not really sure what he thinks he's doing anymore. Maybe he got his law degree from the highly acclaimed imaginary campus of Narnia University. And from what I saw during Judge Slavin's last run-in with Eric Martin, it's clear the judge has had more than enough of Eric's so-called sovereign arguments. Slavin looked completely done with the constant nonsense, the disruptions, and the recycled pseudo-legal lines that never hold up in court. At this point, the judge seems perfectly content, giving Eric's family a bit of peace and quiet by letting the legal system handle him exactly as it should. And if Eric ends up spending some time in jail because he refuses to follow basic courtroom procedure, well, that outcome wouldn't surprise anyone. But jail isn't something you can just talk your way out of with the kind of arguments he keeps repeating. Sooner or later, reality catches up with you.
That you understand what's
All right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
I can't overstate how little patience I have for this guy. Whether he identifies as a sovereign citizen or not isn't really the issue. People can believe whatever odd legal theories they want. What bothers me is that he genuinely thinks the courts have no authority to order him to stop harassing his own family. That level of delusion makes it hard not to quietly appreciate the fact that he's currently experiencing the consequences of his behavior. Sometimes reality is the only thing that gets through to people who refuse to listen. Now, for our final sovereign citizen of the day, we're staying right here in Michigan and heading into Magistrate Hayes' courtroom. This time, we've got someone showing up in a full suit, confidently running the standard sovereign script as if it's some unbeatable strategy. Fortunately, Magistrate Hayes is the kind of judge who handles this stuff with clear reasoning and straightforward facts, shutting down those recycled arguments before they have a chance to gain momentum. I found this clip on old Squishy Gardner's channel, honestly. He's one of the best sources out there if you enjoy watching courtroom oddities and legal nonsense unfold in real time. If you're a courtroom nerd like I am, definitely check out his channel and consider subscribing. It's a treasure trove of legal misadventures.
That is correct.
Yes, Judge.
Let's go have a conversation outside.
You'll be assistant. Okay, so everyone,
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
yes, good morning, Judge. Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements you're talking about. There's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me, so...
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere.
He's asking that question because, in his mind, getting someone to acknowledge that they're bound by previous Supreme Court rulings is some sort of clever victory. He thinks it proves something profound or exposes some hidden flaw in the legal system. But in reality, it's not the impressive move he imagines it to be. It's about as meaningful as asking a math professor whether they plan on using addition and subtraction during an exam. Of course they are. Those are the basic foundations of the subject. Likewise, courts rely on precedent because that's how the judicial system maintains consistency and fairness. It's not a trick, it's not a confession, and it definitely isn't a loophole being revealed. It's simply how the law works. The only people who treat this like a gotcha moment are those who don't understand what they're talking about. To everyone else in the room, especially the judge, just another recycled question from someone who thinks they've uncovered a secret cheat code to the legal system.
Comes to things, and you talk about that, and so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want? All I asked you was this. I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I want to state also that if it was recorded, it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney, So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without,
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did, well, I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
This issue comes up a lot. And although I've touched on it before, I've never really given the full breakdown. So today, I'm going to give you a more complete explanation of what's actually going on. Yes. 18 U.S.C. Section 831 includes a definition that describes a motor vehicle as one used in commerce. That part is technically true. However, the detail that sovereign citizens often ignore is found in the very first line of the statute. It explicitly states that the definitions only apply within that specific chapter. In other words, those definitions are not universal, and they're not intended to redefine every use of the phrase motor vehicle across all federal prof. law when you actually read the entire chapter every section, only to even use the term motor vehicle at all. 3 others use the word vehicle, but one of those is Section 38, which refers to space vehicles. And unless someone has discovered a way to turn a used sedan into a rocket ship, regardless of how much galactic fuel it burns, a car does not fall under the category of a space vehicle. The leap in logic simply doesn't hold up. As for the case he cited, Rodriguez v. Donovan, I have no idea why he would choose that one as evidence. That case dealt with the IRS benefits eligibility, and a situation where the Supreme Court compelled jurisdiction onto a district court that had incorrectly claimed it lacked subject matter jurisdiction. The ruling required the lower court to hear the case not because all laws are invalid, and not because courts can selectively disregard statutes, but simply because the lower court misapplied the rules around jurisdiction. In short, the case has absolutely nothing to do with the notion that Supreme Court decisions erase all laws or undermine the legal system. The interpretation he's suggesting is completely disconnected from what the ruling actually said. It's another instance of someone grabbing a legal citation they don't understand and trying to force it into a narrative that doesn't fit.
We are scheduled for an informal hearing in 2 different cases that arise out of one citation. And those 2 cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had 2 violations listed on it. So it became 2 different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. I guess, Officer Kellums, is there anything before I begin
No, sir.
All right, Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay, and same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof, and in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All right.
I'm not sure why you're asking.
No, sir. All right. If that's the entirety of your argument, then the conclusion is straightforward. You're guilty. And just so we're clear, the phrase right to travel does not appear word for word in the Constitution. Instead, it's considered one of the many unenumerated rights that the Constitution still protects. The Supreme Court has confirmed this in several major decisions, including Shapiro v. Thompson, which makes it clear that the freedom for citizens to move freely from one state to another is a fundamental part of our constitutional framework. In other words, the right exists, but not in the way sovereign citizens often claim.
So if you would both raise your right hands. Very good. All right, Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department. When I observed the vehicle that Mr. Roosevelt was driving, I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or some?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was at issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, contrivance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating.
No, sir. All right. If that really is the full extent of your argument, then the conclusion is simple. You're guilty. Let me clarify something important while you keep referring to a right to travel. That exact phrase does not appear anywhere in the text of the Constitution. It's one of what legal scholars call unenumerated rights, meaning the Constitution protects it even though it isn't explicitly spelled out. The Supreme Court has addressed this principle in multiple landmark cases, including Shapiro v. Thompson, which reinforced that the ability of citizens to move freely between the states is a fundamental aspect of our constitutional system. This right isn't just some abstract idea. It's recognized as essential to maintaining the freedom and mobility that our society depends on. The court has consistently ruled that states cannot arbitrarily restrict this movement, highlighting that freedom of travel is deeply embedded in American law. So yes, the right exists, but not in the way sovereign citizens often try to claim. It's not a loophole or a special exemption from laws. It's a recognized, protected liberty that exists within the broader structure of the Constitution and the legal system. Misunderstanding or misrepresenting it doesn't change the fact that it's subject to legal standards and judicial oversight.
For the purposes of that particular chapter of the United States Code, it would not control what happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
Right, it's a motor vehicle, which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed 2nd 1344.
Okay, but, well, I see what
I've heard your argument.
So there will be no further arguments because I see that you're not going to agree to. Because like I said, I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that a driver license is not a requirement, that you're trying to convert a right into a privilege. to which is covered by Article 1, Section 8, to which
I'll ask you this. Is that right, the right to travel?
that is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered and
now,
unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?
No, sir.